Sorry, Sisanda, it doesn't matter with us because we have 4 repeats for this module. We have it on Monday at 10:30 and Monday again at 2:10. We have it on Tuesday at 10:30 and Tuesday again at 2:10. So today we're following Tuesday's timetable. Yes, it's a Monday, but we used the Monday's link to log on to this class. Okay, and tomorrow we're going to use the Tuesday's link because tomorrow we're following normal Tuesday's timetable. Does that make sense?
Oh, okay. So I belong to tomorrow's 2:10 class and I'm the class rep there. So should I log out here?
Oh, it's fine. It's fine. Tomorrow will be a repeat of today's session. Yes, we have 4 sessions and you guys are split into 4 groups. So 2 groups attend on a Monday and 2 groups attend on a Tuesday. Today we are following, as UKZN, we are following Tuesday's timetable. But with regards to our module Introduction to Commercial Law, we have it on a Monday and Tuesday at set time. So we have 2 Tuesdays. So we decided we'll use the Monday link for today's Tuesday. You can understand?
Okay.
So Sisanda, can you please send me an email? My email address will appear on the module guide, the module outline. Send me an email, your contact details, and I'll take your contact details and we'll take it from there. Okay. So what happens is you can communicate things that you feel like or the class has raised to be very important, to think maybe that the email is going to take too long, okay, or I would not see the email as quickly as I would see the text. So you will communicate that to me and you will not be allowed to actually distribute my number to anyone. It will just be for the purpose of this module. We will be communicating with you and for urgent matters. If I have an urgent matter that I would want to communicate with the class, I will send the email to you. I don't know if you guys keep WhatsApp groups. I know that some of the classes keep WhatsApp groups and usually the class rep is there and will send through all the text messages that are sent by the lecturer to that WhatsApp group. I don't know how you guys operate.
Okay, ma'am, I'll do so.
Okay, all right, but it's up to you. I don't know how you operate. If the way that you've been operating is good, that's fine. Okay, if it works for you, that's fine. So to everyone else that has logged in, my name is Misiwe Nxumalo, and I will be taking you for the next 6 weeks, and we will be doing different types of contracts, okay? Specific contracts like your your contract of sale, sorry, your credit agreements, your insurance contracts, your agency contracts, your lease contracts, and your security contracts. Now you've all been introduced to the basic form of contracts, like for example, your 6 requirement for a valid contract that must be met. You have been introduced to all of those. Now we're gonna look at different types of contracts and we're gonna have a class task that you will need to do. It will be posted up towards the end of October. The date will be confirmed with you via announcements on Learn 2022. So you look out for that. I will also announce in your lectures when that class task will be due or when it will be posted up. Okay. Your upcoming test, I know that you are going to write test 1. Okay. Test 1 is only based on Mr. Kruger's sections. Okay. And he would have discussed what he will cover in test 1 with you. With regards to test 2 will be a combination of my sections and Mr. Kruger's sections, and he will also communicate with you what sections will be covered for his part in test 2. Well, for my part in test 2, we'll cover part C and part D, which is contract of sale and credit agreements, okay? Then you'll have your test 3, okay? That will solely be what we covered, okay? So it's Miss Misiwe Nxumalo's sections. So that will be part E to part H. So you will cover your insurance, your agency, your lease, and security. Okay, structure of your test, multiple choice questions and short questions that will require you to apply yourself. So we're not going to ask you in your short questions, list the requirement for a contract of sale. That's not going to be the case. You are going to be, you're going to need to apply yourself. You're going to be given a scenario. You need to give advice. So you need to read a case that maybe I refer you to. You will need to read it, even though there won't be much of that because you guys are not strictly law students, but you have to know how to apply yourself in a situation. Okay. With regards to the textbook, it's a very same textbook that is used by Mr. Kruger, the Law of Commerce in South Africa. So you guys have already got access to the textbook. I think there's also an electronic version of the textbook. Someone can confirm that?
Yes.
Okay. You guys use the electronic version of the textbook. All right. Okay. Are there any other admin issues that I didn't deal with that you guys feel like I should deal with? Okay, if there are no questions, I will start with the lecture. We have a very limited amount of time to deal with everything in the lecture. So recordings will be posted up for you guys to view at your own time, but it must be on that set week for you to be on par with your studies. Okay, so Introduction to Commercial Law 2022. Okay, let's look at sale agreements. Before we look at sale agreements, could you guys remember what are the requirements for a valid contract? Anyone? Lerato? What are the requirements for a valid contract? Wouldn't it be your contractual capacity, the fact that someone is of the right age to enter into a contract, okay? Or to perform any legal activities? Wouldn't it be that? 1, 2, consensus, the fact that both or the people that are entering into a contract are at the same level in terms of the mindset, they understand what they want from this contract. Formalities, okay, could be formalities prescribed by the law or formalities that the parties agree to. For example, we want our contract to be in writing, failing which it won't be a valid contract or it won't be enforceable. So it could be formalities that are required by the law. For example, the contract of surety needs to be in writing. If it's verbal, it's not existent, it's a void contract, okay? Certainty, okay, certainty in contracts, possibility of performance will be your other requirements, and the 6th is legality. So beyond all of those requirements that are required for a valid contract, we need to now specifically make the contract of sale special. There are some requirements that make the contract of sale special. Yes, it needs to have all these 6 requirements for a valid contract, but in order for it to be a contract of sale, there are further requirements that must be met. So let's look at our notes. Law of contract is specialized part of, law of sale, is a specialized part of the law of contract, applying additional requirements to that of the general principles of contracts, like I've discussed, your requirements of consensus, the fact that there must be meeting of the mind of the parties that are entering into a contract, the requirement of lawfulness, the fact that it must be a legal contract and illegal contracts will not be enforceable, capacity, okay, people must be of the age to enter into that contract, okay? Formalities, if there are formalities required by law, when we entered into that contract, did we in fact abide by the formalities required by the law? Or Did the parties to the contract agree to any formalities? Are those formalities in place in the contract? Okay. Possibility of performance. Is it possible to give or to perform in terms of this contract? Okay. So beyond all of these requirements, you need additional requirements to now make it a special contract of sale. So similarly, the same requirements for breach of contract exist with additional consequences ensuring for a contract of sale. So when we talk about breach, again, breach of contract, okay, same requirements will apply for breach, but there are additional consequences because now it's a special contract, it's a contract of sale. Okay, law of sale examines the requirements for there to be a valid contract of sale between the parties and the consequences of a contract characterized by a sale. Now, there are fundamental concepts that you need to familiarize yourself with when you're dealing with the contract of sale. Owning something and possessing something are two different things. Does anyone know the difference between the two? Is there a difference? Yes, there is a difference, but does anyone know the difference between the two? Owning something and possessing something. What's in Pile? Amira, do you want to give it a try? Okay. All right. So owning something means that you have a very, it is a strong right, okay, against anyone. Okay, it's a real right. It's a strong right. It's the most powerful right when you own something. It's a right that you can use against anyone who wants to dispossess you of that item that you own. Possessing something means that you're merely holding it, but you don't have ownership. It means that when you're passing it on to someone else, or if you sell it to someone else, okay, you are not passing on ownership, okay? The owner, the true owner still has the right to come and get it from the person that you've sold it to. So it means that you're merely holding it in your hand and you don't have that real right of ownership, okay? As well as the risk, okay, in that the transfer before possession does, okay, intangible things such as copyrights can be sold, as can things one does not own or possess or that even exist, okay? Contracts of sale is commonly or most commonly is the most commonly encountered type of contract in practice because people transact on a daily, okay? Beyond the contracts of sale, or when we are talking about the contracts of sale, we cannot leave aside your National Credit Act and your Consumer Protection Act. The law of sale has become considerably more complicated since we've introduced the National Credit Act and the Consumer Protection Act. Okay, does anyone know what the National Credit Act deals with? Anyone? The Consumer Protection Act. So the National Credit Act will apply to credit agreements, and the Consumer Protection Act will mostly, just a broad, to give you an idea, just a broad definition, will mostly deal with contracts that deal with your consumers, and it would allow or give way for consumers to be protected in this harsh environment of your commercial environment. All right. Okay, it can be said that the law of contract therefore has three distinct sections. Okay, we have the common law, which deals with our law of contract, our terms according to the law. We have the Consumer Protection Act, and we have the National Credit Act. The common law of contracts and sale, which applies to all commercial contracts and to consumer contracts insofar as the Consumer Protection Act and the National Credit Act does not override the common law. And then we have your consumer contracts and consumer sales, which are governed first and foremost by the Consumer Protection Act, unless they are governed by the National Credit Act. Your consumer credit agreements, which apply to the exclusion of the Consumer Protection Act, except in so far as goods are concerned. And for the purposes of this lecture, we will focus on common law contracts, okay? We will focus on common law contracts, but we will also keep in mind that we have the National Credit Act and we have the Consumer Credit Act. Now, what's a definition, or how can you define a contract of sale, or how can you define a sale? So usually a contract of sale will be concluded with the owner, okay? If a person wants to have ownership of something. So if you want to have ownership of something, you will approach the owner of that thing, or a person that you see as the owner of the thing, and you will give them an offer to say that you want to purchase this, and they will agree, accept your offer, and then a contract will be concluded. However, it is not a requirement for a valid sale contract that the ownership must be transferred from the seller to the buyer. Okay, what's important is that the seller must give the buyer undisturbed possession of the object, which means that the seller can then now sell something that does not belong to them or something they do not own. Okay, so it's a very complicated definition, okay, but a commonly used definition of sale is when parties who have the required intention agree together that one party will make something available to another, okay, in return for a payment of a price, okay, or of a purchase price. But also this definition again has been criticized because it causes a confusion between the contract of sale and the contract of lease, because in a contract of lease, one party also agrees with the other party to make something available, which is a vacant building, okay, in return for a purchase price. So also this definition is also very ambiguous, and it does not then distinguish between a contract of sale and a contract of lease. Okay, what are the special things or characteristics that then make a contract of sale, a contract be a contract of sale? So in addition to all your 6 requirements that we've listed, your contractual capacity, your possibility of performance, your consensus, your formalities, your legality, over and above all of those 6 requirements, you need to have these 3 requirements in order for the contract to be a contract of sale, or to be categorized as a contract of sale. Firstly, there must be an agreement on the object of sale. Secondly, the seller must promise to transfer ownership. And remember, this is not a requirement, so we have or to deliver undisturbed possession to the other person on a permanent basis. And thirdly, the buyer must promise to pay a specific or determinable amount in return. So these are the 3 things on top of the 6 requirements that then make a contract of sale. So if there is no object, it cannot be a contract of sale, okay? If the seller does not promise undisturbed possession of a thing on a permanent basis, it would not be a contract of sale. If there's no payment in consideration, okay, for getting something, it is then not a contract of sale. Over and above the 6, there must be the 3 requirements to make it a contract of sale, where a contract provides that the buyer will not receive ownership or permanent undisturbed possession. The contract is not a contract of sale, like I've explained, where both the parties know that the seller is not entitled to sell the thing. For instance, where the property is stolen, the contract will be void, and it will be void for illegality in those instances, okay? Or impossibility, all right? Now we're going to discuss each of the requirements, okay, the additional 3 requirements that will make a typical contract a contract of sale. Are you guys still with me?
Yes.
Are you guys with me? Okay, can I also get a thumbs up from other people? Just as an indication that you're still with me. Okay, let's now discuss these 3 essential requirements for a contract of sale. Okay, so we looked at the requirements for a contract of sale, the 3 requirements, and those are in addition to the 6 requirements for a normal contract. Okay, now we're going to look at the three in detail. Okay, what are the three? There must be an agreement on the object of the thing that you are selling. Okay, so the buyer and the seller must agree on the object. Secondly, the seller must promise undisturbed possession. Okay, and thirdly, the buyer must then pay an amount of money to the seller. Okay, let's look at number one, the agreement on the object of sale. So the object must be determined or it must be determinable. Okay, the buyer and the seller must reach an agreement on the identity, whether it's a specific object or the nature of the object, if it's something that is generic. Okay, the identity or nature of the object sold must be determined or determinable at the time of the conclusion of the contract. Okay, so if you enter into an agreement and you say, we'll see what I'm going to pay you for, that's not a contract. It must be something that is known between the parties. For example, if I say you're a carpenter and I say I want you to make a table for me, it's something that is generic. I'm stating the nature of the thing. Okay, so it will compromise as a contract. Okay, the identity or the nature is determined or certain if the parties know exactly the identity of the object that they are entering into a contract for. If the identity or the nature of the object is not certain or ascertainable, the contract will be void for vagueness. Okay, remember, there must be certainty in a contract. Your 6 requirements for a valid contract, there must be certainty. So if the object or the identity or the nature of that object is not ascertainable by the parties, okay, that contract will now be void because it is vague. It is therefore important to ensure that the object is sufficiently well described within the contract. Okay, so we have different types of objects that parties can enter into contracts for. We have movables, okay, things that you can move from one place to the other without it being destroyed. So you have your clothes, your chairs, your food, your vehicles, your computers. Okay, so you can contract for movable things, immovable things, okay, things that you cannot move from one place or the other without it being destroyed. So it's something that is permanently attached to the land and anything that is attached to it. So you're looking at your house, your vacant land, your agricultural land. Okay, so your urban areas, your buildings. Okay, so you're looking at things like that for immovable property. Okay, you can also, parties can also contract for specific things. Okay, in some cases, the identity of the object being sold may be of importance and will be the case where a specific building is bought or where a truck is being sold, or the identity of such cases will have a direct bearing on the value and consequently the price of the thing. Okay, so it's something that is specific or something that is generic. Okay, in many instances, the exact identity of the thing sold is of little importance, but the nature or the type of thing is very important. So it's something that's generic. For example, a kettle from Macro. Okay, you can contract for corporeal or incorporeal things. Either the thing may either be tangible or intangible, or maybe a physical object or a creation of consciousness. For example, your shares, you can contract for shares. Okay, you can contract for something that will be that is not in existence now, but will be in existence in the future. For example, I might say, please make a piece of furniture for me. The piece of furniture is not in existence, but it will be in existence in the future. All right. So that is allowed as long as it is described in the contract, okay, or the terms of the contract describe and determine what the object is. Okay, the sale of certain types of object may be prohibited in total or restricted subject to conditions. So most of these restrictions have their origins from specific pieces of legislation. An agreement which is in contravention of a legislation will then be void for illegality illegal contracts must be distinguished from contracts that will be invalid for non-compliance with the formalities. Okay, so if we say a contract is void for illegality, it's because you entered into a contract that is prohibited by statute. For example, the sale of marijuana. Yes, you can use marijuana in your private space, okay, but you're not allowed to sell it so without the correct license. But if you sell it in a black market, okay, without the correct procedures, then it will be void for illegality. So if you give money to someone and they don't give you the marijuana, you can't take it to court because that contract is void because it is illegal. Okay, now illegality must be differentiated from invalid contracts because they don't comply with the formalities. For example, one of the formalities and most important formalities according to the Alienation of Land Act is that contracts for buying and selling land must be in writing. And if you don't put that contract in writing, that contract will be invalid for non-compliance with the formalities that are required by the law. So know the difference between the two. So note that there are consequences of invalidity and they may differ in terms of the invalidity that is caused by the contract. So invalidity for illegality, invalidity for non-compliance of the law. There are different consequences in that manner. The seller does not have to own the thing, okay, for it to be sold. We've already spoke about that. He or she must just promise the buyer undisturbed possession or use or enjoyment of the goods. Okay, so you don't have to own the object in order for you to conclude a valid contract of sale. There are situations where goods belonging or not belonging to the seller can validly be sold, and look at these 4 situations where the seller sells a generic good that it reasonably expects to receive from its suppliers. Okay, you can easily sell those items that are generic. The seller sells a specific thing which it reasonably expects to obtain from the owner. The seller fraudulently sells someone else's property without any reasonable belief that they will obtain the property. And lastly, the buyer has bought goods in terms of an installment of sale where ownership of the goods has been restored by the original seller until payment in full has been received. Okay. Where goods have been sold and delivered by a person who is not the owner, the true owner can come back and claim the goods from the person who now possesses them. And remember, if you buy goods from a person who's not the owner, remember, ownership has not transferred to you. So you are merely the possessor. And that is why I said you need to know the difference between ownership and possession. You're now the possessor and the true owner, because the owner has the most important real rights. They can come and take it, okay, and take the item that you now possess, that you think that you own, okay, that you now possess, and that action is called, or remedy is called, the action re vindicatio. This action provides a strong protection for someone who's the true owner, whilst the person currently in possession must then rely on a claim for damages from the person who sold it to them in the first place. So you don't fight with the person who is now taking it, who's the true owner. You go back to the person who sold it to you, who was not the true owner, and you fight with them. Obviously, you're going to claim for damages. If something happens that the owner sells or that the owner sells an object to 2 different people, okay, we call that a consecutive sale. So what happens in situations like that? Okay, so you'd find that a person, okay, for example, seller A has a car on the market and he wants to sell the car for 300,000 rands, and he approaches B. B then agrees and say, okay, fine, but I will buy it for 250,000 rands. So there's a contract between A and B. A car is being sold. They've considered the amount of payment, and A is now promising to give B undisturbed possession of the car. That's a contract. But A then now receives another offer from X, person X. Okay, so person X says, I will buy the car from you for 300,000 rands. That's higher than B, and A now wants to opt to buy for X to buy the car because now X is offering a higher amount. Okay, fair. All right, so it's where A has now entered into a contract to sell the same object to two different people. It's called consecutive sale of the same thing. This situation can be resolved in a number of ways, depending on whether delivery has occurred or not, or where the second buyer was aware of the agreement between the seller and the buyer, okay, in the first place. So look at page 151 to see how it can be resolved if the car has now been delivered to B or X. How would that contract be resolved, or how would that dispute be resolved? How would it be resolved where a car has been delivered to X, but X was unaware of the first contract, okay, at the time of delivery of the vehicle, or where the car has been delivered to X, but X was aware of the agreement between A and B? How would that then be resolved amongst the parties? Okay. Let's look at your lecture 2. Okay, and in this lecture, we'll talk about the second requirement for a contract of sale. Okay, remember we said that the 6 requirements, yes, they are in the background, but now we are talking about a specific kind of contract. It's a contract of sale, and in this contract of sale, we know that we must have 3 things over and above the 6 requirements for a valid contract. We must have the agreement of the objects to be sold, and secondly, the seller must transfer ownership or deliver possession, undisturbed possession to the buyer, okay? So normally a buyer wishes to obtain ownership of goods bought. If the seller is the owner, then they are obliged to transfer ownership to the buyer. So if the seller is the person who owns the thing, then might as well transfer ownership to the buyer. However, like we discussed, there are certain instances where the seller is not the owner of the property, but still sells it to the buyer. Then there is no obligation on the seller to transfer ownership. But once they've obtained ownership, that they need to transfer the ownership to the buyer. Okay, concluding an agreement of sale does not transfer a real right of ownership. It creates a personal right between the two parties, the seller and the buyer. What do we mean by this? Okay, so A and B enter into a contract, okay, for A to sell his car to B. That's a mere contract, okay? It creates a personal right. So if B pays A the money and A does not deliver the car, then B can only go after A for delivery of the car. Cannot go after A's mother, after A's cousin, or after A's friend. It means that a personal right has been created between the two people, and that right is only enforceable against the other party who is in the contract and no one else who is not in the contract. But ownership is transferred for movable goods by delivery or immovable by registration at the deed office. So that's when ownership is transferred. So know the difference between the two, that when you conclude an agreement of sale, okay, a personal right is created between the parties to the contract. But now when we deliver, okay, the object that is being contracted, then ownership passes, but ownership will only pass if the person who's selling is the true owner. So until delivery, the buyer has no real right to the object itself. It means that one can validly sell something which does not belong to them, like we've said in the past. Okay, if the seller innocently sells a good which is owned by another person, but the buyer cannot sue the seller until such time as the owner recovers the goods. If the seller fraudulently sells the goods, only then can the buyer immediately cancel the contract and sue the seller for damages. For ownership to pass, a court will look at these 3 elements. Firstly, is the seller or the seller the owner at the time of delivery? So is the person who's selling the thing the owner or has the right of ownership at the time of delivery? And secondly, the seller must have intended to pass ownership to the buyer on delivery. And thirdly, the buyer must have intended to acquire ownership at the time of delivery. So if these three things are there, okay, then the court will then look on at each case on a case-by-case basis to see whether ownership has indeed passed. Okay, but we know that if you're not the true owner, then ownership cannot pass. You can only possess the item that you have bought. Okay, ownership is different from possession and may pass at different times. Ownership of movable and immovable things will pass at different times. Remember, we say that with movable things, ownership is passed when delivery is made, with immovable registration at the deeds office. The transfer of ownership, okay, is determined in the contract itself, for example, sale installment, and where it is not stipulated in the contract, it is determined by common law. Here we are distinguishing between a cash sale and a credit sale. Does anyone know what's the difference between a cash sale and a credit sale? How would you differentiate between a cash sale and a credit sale? Yes, Sisanda?
A cash sale is where you pay as you take the product, and with credit sale, you take the product and you pay later.
Okay, thank you so much, Shisanda. All right, so with cash sale, the intention of the parties to perform simultaneously. As I deliver something, you pay me the money in consideration for the thing. A credit sale, the intention of the parties to deliver first and payment must come later. But what is the presumption of the law? A contract of sale is a cash sale unless it's specifically stated by the parties to be otherwise. Okay, so that's the general rule that is followed by the law. So in a cash sale, ownership passes once the purchase price is paid in full, and in a credit sale, ownership passes immediately upon the delivery of the goods where there is intention to do so. Remember, when you go to a garage and you buy a car, that maybe you sought finance from a bank, okay? The bank owns the car, because there is no intention from the bank for you to own the car, which means that even if you sell the car to someone else, you cannot pass ownership to that other person, because the true owner of the car is the bank. Okay. Factors recognized as indicators that a contract is a credit contract rather than a cash sale. Look at these indicators that you look for: postponement of a sale, security was asked for and it was in fact given, the seller knew that the goods were bought for immediate resale, okay, payment on interest agreed upon, ongoing practice of dealing on credit parties, acceptance of post-dated checks, and where it is customarily sold on credit. Okay, and this delivery of undisturbed possession of the goods. Okay, primary obligation of the seller is to make the thing available to the buyer or to deliver the thing to the buyer. After delivery, the buyer is free to use and enjoyment without permission or interference from the seller. What are your exceptions? Okay, sales on installments or installment contracts. Those would be your exceptions. Okay. The place of delivery, so unless otherwise specified, the seller's only obligation is to make the thing available to the buyer. So if you have a shop and you're selling laptops, the buyer must come and fetch the laptop, collect the laptop from you. Okay, the buyer must remove at his own cost and his own effort, and the goods must be presented in a state fit for transporting. In the case of immovable property, the seller must provide the buyer with access and possession of the land, and this includes all necessary steps to transfer the land. Obviously, transfer takes place at the deeds office. Now, there are different modes of transfer or delivery, different modes of delivery. Okay, know these modes of delivery. In your page 154 of your textbook, you'll see that they talk about actual delivery, where you physically deliver something. You take the phone, if it's a contract of sale for a phone, and you deliver it to the buyer. That's actual delivery. Delivery by shorthand, for example, I lend you a textbook, the Law of Commerce textbook, and it's with you. And then I realized 3 months down the line that I don't actually need the textbook. And I tell you that, in fact, I want to sell the textbook to you, and you agree, and you say that you're gonna pay 300 rands for it. I agree. You pay 300 rands, okay? But the textbook is still with you. Do I have to deliver it? No, it's delivery by shorthand. Know what's delivery by longhand, know what's atonement, know what's constitutum positorium, and know what's symbolic delivery. An example of symbolic delivery will be when you're giving someone a key, okay, to a car. So you're giving them access to the car. So you're giving them something that's an accessory that will allow them access to a car. Know what these forms of delivery mean, okay? Know how to define them and know how to give examples. Okay, the time of delivery, it must be made available immediately at the conclusion of the contract. If not immediately, then it must be made available at a reasonable time. Okay, we're talking about the time. Right, and the third thing that will make, or the third characteristic that will make any contract a contract of sale, okay, would be the price. So the price must be certain, it must be ascertainable, meaning that the price must be determined or determinable, or may be paid partly in kind, or although the intention of the parties will be determined, will determine if it's a barter or it's a contract of sale, okay, using your cash transactions. Okay, so the consideration must be stipulated. We are selling this car and I'm selling the car to you for 300,000 rands. Maybe you're gonna give me your second-hand car and then you're gonna give me 100,000 rands over and above that, okay? Contract of sale, it must be certain that what am I getting back in consideration for the item that I'm giving as the seller, okay? The reasonable price, usual price, market price can be used to indicate the price, okay? So it does not have to be an actual figure. You can use the words reasonable price, usual price, okay, market price, okay, in your contract, but these terms are not ideal because it then leads to a dispute between the parties that are entering into the contract, okay? Prices that are based on estimates, the purchase price may be determined with reference to a specific object or with reference to certain quantities, okay? Maybe per kilo, okay? You go to a butcher and they say, I'm selling mutton 99 rand per kilo, okay? Can be determined in those ways. Disappropriate appropriate values, sale or donation. So due to freedom of contract of sales, will seldom meddle in contracts where the value of price is disproportionate unless it appears to be fraud, okay? Know how to distinguish contract of sale against other contracts, like distinguish a contract of sale from a contract of that's a barter, where there is no payment of money, but parties exchange goods. That will be a contract for a barter, and a contract of lease, obviously, where now the landlord has intention or agrees to give use and enjoyment of the property to another person in return for payment of rent, okay, can be distinguished from a contract of sale because the landlord is giving a limited period of use and enjoyment. Whereas if you're selling something, you are permanently, you're giving a permanent enjoyment, permanent use, unlike your lease where you are giving a limited period. Okay, contracts for work or services, know how we can differentiate contracts for work and services against your contracts of sales, and obviously your contracts of software licensing, okay, because we know that companies may buy your tailor-made softwares or they may buy your standard form software contracts. How do we distinguish that from a contract of sale? Okay, now we're looking at freedom of contract. Okay, this is a cornerstone or core value on which the law of contract is based. And this principle basically means that parties can structure their contract in whatever manner they wish to structure them, as long as it's within the bounds of the law. There are few circumstances where the legislature or the law will now intervene to say, no, you can't do this when it comes to contract, but parties are free to structure their contractual relationships according to their own wishes. Okay, courts will also hesitate to interfere when parties have entered into a contract, and usually parties will, the courts will be the last resort, or it will be the last resort for resolving contractual disputes where parties have now entered into a contract and there's contractual dispute. Usually you'd find that there's a clause in the contract that says that parties need to go for arbitration before they can actually approach a court of law. Okay, so that's the concept of freedom of contract. Know what it means, familiarize yourself with the concept of freedom of contract. Okay, protection, consumer protection legislation. We touched on the fact that, you know, the contract of sale has 3 distinctions: your common law, your National Credit Act, and your Consumer Protection Act. Okay, but with regards to your consumer protection legislation, we have the National Credit Act, which is an example and is an exception to the general rule of freedom of contract. So if in your freedom of contract you defy the National Credit Act, your contract might be voidable, or it might be void, or a certain provision in your contract might be void because it goes against the National Credit Act. Okay, also the Consumer Protection Act is also another example that intervenes or limits the right to freedom of contract between the parties. And you'd find that there are standard terms that are used in a contract, and usually your banks will use standard terms and conditions as recognized in business. However, in order to use these terms efficiently or effectively, they have to be specifically brought to the attention of the other party. So now there have been a lot of cases where the court has been fighting your big institutions, like your financial institution, especially like your banks, that they don't point out or highlight the very important clauses or harmful clauses to a client. So you'd find that your consultant at the bank will then make you sign next to that clause to say that they have actually highlighted it to you and pointed out to you. Okay, terms implied by the law. Okay, these are terms that are implied by the law. So even if the parties have not agreed to the terms, these terms are implied by the law. For example, your duty of the seller to take good care of the goods that they are selling, liability of the seller for latent defects, for something that can't be seen by an ordinary person or a reasonable person, a seller's warranty against evictions, liability for the seller for innocent misstatements. Okay, the duty of the buyer to remove the goods from the seller. So these are all the terms that are included in the contract if the parties have not touched on it. So a contract will just not be void because the parties does not touch on those terms. The law will then say, okay, this will be a naturala of this contract, so therefore it should be read into the contract and included into the contract. There's no need to make the contract void. Okay, then you look at your commonly included terms in a contract. Know what a footstool. Okay, sale on approval clause. Okay, you're free on rail, you're free on board, your cost, insurance, and freight. Know all of those terms. Okay, I know that we've ran out of time, so the remainder of your lecture, or part 3 and part 4, will be uploaded so that you guys have recordings and you guys can go through the notes at your own time. Yeah, are there any questions with what we've covered so far? Any questions? Okay, if there are no questions, if you guys would like to join tomorrow's lectures, you are free to join tomorrow's lectures, and I will see you then. Okay, thank you so much.